Igamba rĩa impeachment ya mukathe Bishop Kawira Mwangaza nĩrĩambĩrĩirie kuthikĩrwo ntuku ya narua koti ya Milimani Ruterero Nairobi. Aria mawakili baria barungamirite mukathe Bishop Kawira Mwangaza batongeretwe ni Elisha Ongoya nibombire kwithirwa bagitariria mantu yetano jereba kuga mutaratara juju jutombire kwithirwa jugitithwa na mbere bure kubatere na nkulukini nibombire kwithirwa bakiuna watho gwitithia na mbere mutaratara juju.
6 issues for determination are: 1, whether the impeachment of the petitioner was invalid for being in defiance of a valid court order. The second issue is whether the impeachment of the petitioner was invalid for being predicated on matters sub judice. Those who are pure Latin speakers will call it sub judice. The third issue is whether the impeachment of the petitioner was invalid for being conducted in contravention of the petitioner's right to fair hearing. The fourth issue is whether the provisions of Section 33, subsection 8 of the County Governments Act contravene Article 50, Clause 2, Paragraph O of the Constitution of Kenya, and hence is unconstitutional. 50 Clause 2, Paragraph O. Unconstitutional, yes. The fifth issue is whether the threshold for the impeachment of the petitioner was in fact met. And the sixth issue is whether the impeachment process was in compliance with the established principles of public participation under Article 10 of the Constitution.
Nkuluki Ongoya natarĩrĩte County Assembly ni aunire watho bwa koti riria yetithirie na mbere mutaratara juju na koti irutite itware mutaratara juju jwa impeachment jugeta na mbere ni aria baugite kinya Senate ni ombire kwithirwe kiamukira mutaratara juju na kinyayo yomba kwithirwe igijuitithia na mbere na yomba kwithirwa igijukurukia untu buria ongelete na kuwa gavana ataero kanyaga kega gakwithetera.
Allow me to start with the issue of whether the impeachment of the petitioner was in contempt or defiance of an order of court, and I'll also be submitting on the consequences of that.
Yes.
Well, my late Professor Okoto Gendo used to tell me that there can be no issue of law without an issue of fact. Let me begin by raising the factual issues. When you look at volume 1B of the petitioner's document, you will find Annex BKM2 to the supplementary affidavit sworn on 4th September 2024 by the petitioner. At page 369 of that affidavit is a letter dated 9th August 2024 from Mutuma Gishuru and Associates Advocates to the Speaker of the Senate and to the clerk of the Senate.
Yes.
On the face of that letter, you will see receiving stamps by both offices confirming receipt of that letter.
Yes.
That letter conveyed to the two offices a ruling by Lord Justice Kassan,
Yes.
delivered at Meru High Court on 24th July 2024.
Yes.
At page 4 of that ruling, which is available at page 374 of the volume,
Yes.
the court ruled, and I quote, "The upshot of the above is that the impeachment process is halted pending my ruling."
Yes.
The upshot of the above is that the impeachment process is halted pending my ruling, and since this is a matter of public interest, the rulings will be delivered on Monday, the 29th of July, 2024.
Agitariria Nkuluki wakili Mutuma na ugite County Assembly ni unire watho bokoti na nande County Assembly Clerk, Speaker na mover wa motion ijuju uria ni MCA wa Kuorota Zipora Kinyaka na ZNK nibombite kwithirwa bakigwatwa na maitia na gutwirwa kibungo kia mieri 6 aria wakili Mutuma ugite na kurigara kuona no bakwanganga ome.
I want to submit that the governor has established a case for the following. One is that Article 181 of the Constitution
Just a moment. Yes.
as read together with Section 33, and this time I'm referring to Section 33 as a whole, not 33.8,
Yes.
that any person seeking to invoke those two provisions must do so within the authority of the Constitution.
Yes.
It has been established without a shadow of doubt that the respondents' fourth, fifth, and sixth respondents, interested parties rather, did not have the authority of the law to proceed with impeachment. For the simple reason that they had been prohibited expressly from proceeding with the impeachment process by a valid court order. As we speak, Your Lordship, the County Assembly of Meru,
Yes.
the Speaker of County Assembly of Meru, the mover of the motion, one is Paul Kenya, are convicts. They have been found guilty.
The Speaker of the County Assembly.
The mover of the motion, one is Paul Kenya, and the County Assembly of Meru
Yes.
are convicts. A court of competent jurisdiction has sentenced them to a period of 6 months imprisonment. I am surprised to see that they are hovering around.
I'm not recording.
What then needs to be done, Your Lordship, is for them first to purge the contempt. The Commissioner has been able to establish that her right to fair hearing has been, one, threatened to be violated by the County Assembly of Meru,
Yes.
and indeed violated by the respondent in this matter by failing the impartiality and independence tests as expected under Article 50 of the Constitution.
Yes.
By way of summary, Your Lordship, is that a decision was made to remove the petitioner before the actual voting took place, and indeed that decision was communicated. There is no other clear indication of lack of impartiality, lack of independence, and failing to uphold the right to presumption of innocence.
Yes.
That action alone is enough to demonstrate that the Senate was not only biased, but very much partial.
Yes.
Related to that, Your Lordship, is that we have been able to demonstrate
Yes.
that the County Assembly of Meru, together with the Senate, exploited an inconsistent provision of the law, that is section 33(8), and went against the rule of against double jeopardy. That is a violation of the right to fair hearing.
Yes.
Your Lordship, as you go through the public participation report, you will discover that there was no compliance with the principles under Article 10 of the Constitution. What has been presented to you is shambolic and a mockery of the process. Having done
Kuluki mawakili babane baugete ni bategerete na bona Gavana Mwangaza na thithiritwe impeachment inyingi na ya mbere ntuku inka yake nyuma yawe kunyumuma jo gutonya obisine aria baugete atari kinya ari kuthura kanjo yawe ya mawaziri bakumutetheria kurita ngugi.
The petitioner is the first governor, my lord, in the history of devolution since its inception, to face 5 charges, 5 impeachment attempts, my lord. We have been able to set out the various impeachment process that she has been able to go through in our affidavit,
Yes.
with the first one being, I think, 57 days after the inauguration, my lord. This impeachment came in at a time when the governor had not even set up her county executive, my lord.
Yes.
Which then means that she had not been given ample time, or rather sufficient time, to be able to put out the governance structures so that she can be able to implement the manifesto that she had for the people of Meru, my lord.
Yes.
The repeated impeachment attempts, as outlined in the proceedings, my lord, we submit, have far-reaching implications, my lord, on the governance of the county government, my lord. My lord, the governors, as well as other state officers, come into office on the basis of universal suffrage, my lord. They are elected by a majority. It defeats public interest, my lord, for any state officer elected into office to be subjected to continued and repeated, as has been demonstrated by the petitioner through her counsel,
Yes.
impeachment attempts, my lord. What then is the public interest, my lord? That the county government is always in a mood, or rather a mode, of an impeachment.
kiri wakili uria urungamirite ruterero mawakili baekuru na ugite ngavana atairo kanya gakega gakuthikirwo ni Senate na nkuluki agweta county assembly gutumira mwekuru kurana mwekuru ungi aria auritie mugambithania gutegera untu bobo muno bwa ekuru kwinyirwa baria bari utongeriene aria etanite mung'wanano jwa Anirita uria wari mubunge wa mwekuru wa mbere aja kaunti ya Meru ende omba kwithirwa kingwa gitine.
Thank this court for enjoining FIDA to this matter because one of the key components and assignments of FIDA since establishment in the 90s is to advocate for women's rights, and that means all women from all walks of life. Shades, shape and sizes, including the governor for Meru County. So the work you're doing today, Honorable Judge, is a very serious assignment for the women of Kenya, all the well-meaning women of Kenya. My Lord, that is why the impeachment of Governor Kawira Mwangaza must be quashed. This is because since 1963, that is 12 December 1963, what the people of Meru County Assembly have done to the governor has been the greatest affront to realization of women's political rights in Kenya. There has been none worse than that, my Lord. Perhaps and because I had counsel refer to Anarita Karimi, I would like to say that we can only compare what she's going through to what that lady Anarita Karimi went through. She was not only bundled out of parliament, but she was also jailed in a very discriminatory manner. And I wish to say that there are various similarities between these two women. One of which is that they are both from Meru community. So, what I would like this court to do this afternoon is also to focus on this community of Ameru and how it is that they view women. Because since 1975, my Lord, I see you thinking. Rita was elected, the second other elected woman from the community is Honorable Kawira Mwangaza to that level. There has been no other parliamentary elected woman in a contested all-gender election since 1975. Why am I saying this? It's because I don't believe it will be possible to give a fair, full and final determination of this matter without looking at the social and cultural aspects of the society. In the morning, when the question of what the Meru court meant by saying, using the word that there is a possibility of some gamers behind this scheme, I had an opportunity to review the videos before I came to court. And I would like to refer the court to some of the video recordings which will support our position. KMV 12, KMV 15, KMV 17, and 11. My Lord, when you look at these videos, you will understand, and you are there on the online platform when you are requesting to join as interested parties. You saw the level of abuse.
Yeah.
And it is typical of a patriarchal society to get a woman to fight another woman, my Lord. This morning we saw one lady by the name Zipporah, who is a sixth interested party, who, having no faith in her counsel, wanted to stand up and address you. And I'll tell you why.
Mugambithania Bahati Mwamuye na ugite Igamba riri arigeta na mbere ntuku ya Jumatatu tariki 24 cia mweri Juju akuambiria thaa thita cia muthenya.
So that is the conclusion of highlighting of written submissions for those in support. we will reconvene on Monday, and the session shall be as follows: from 12 noon sharp to 3 p.m. Then we'll take a 30-minute break. Please carry packed lunch so you don't need to leave the premises. Then we'll go from 3:30 until whatever time we conclude. But I hope we will be able to do 12 to 3 for those opposed. If there's a little bit of spillover, that is understandable. And then a rejoinder limited to only the petitioner for about an hour.